supplementary list, item number 1.
Please, Your Lordship. Lordship, this matter I'm appearing on behalf of Mr. Estapa, Your Lordship. Lordship, today he's having some personal difficulty, Your Lordship. So I pray that the matter may come up on Monday, Your Lordship. On pre by Mr. Learned Counsel, seeking accommodation on the ground that the Learned Conducting Counsel is indisposed, whereas adjourned. This is the same on Monday. I'll oblige, Your Lordship.
Item number 2.
Morning, Your Lordship. So this application is under 403 of the BNSS, parametria to 362 of the old code. So it's just for rectification of a clerical error in a common judgment and order pass. I may be allowed to.
What about the other side? No. Chief, yes.
Anyone can appeal. Just for rectification of a clerical error in a judgment.
Well, I'll just.
Sure.
I need one copy, Lord Chief.
Copy. I'll just share it because it's just one paragraph.
If this matter come on service coming.
Sorry, Your Lordship.
Number 2. Yes. If I may, move.
Yes, please.
Sorry. Lordship, the individuals who have preferred a bail application, which were registered as bail applications 42, 44, 45 and 46 of Lordship, and they had preferred the bail application in connection with Nongpo PS case number 25-3 of 2024, which has been mentioned in the title as well, cause title, etc., etc. But inadvertently, Lordship, perhaps when the bail was order was being typed, when the common bail and order was being typed, which is at it's paragraph 6, particularly, Your Lordship. I'll take you to the concerned common order and judgment. It's paragraph 6, Lordship, of the judgment, which is at page 11. Page number 12, Lordship.
Para 6 is here.
Para 6.
Page 12.
Page 12.
12 is the course title.
I'm sorry. Para 6, Your Lordship. I may have numbered it wrong. I'm sorry. Page 15. Page 15.
14. Starts from 14.
Yeah, starts from 14. If I may be allowed to read the same, Lordship.
Yes.
Now at present, Mr. S.S. Yadav, learned counsel for the petitioner, had again approached this court making similar submissions. Similar contention, more particularly seeking bail on the ground of parity, in as much as the 3 accused persons in these 3 separate applications, though they were arrested in connection with the said Sadar PS case number 83 of 2024. So therein the clerical error has been made, Your Lordship. It's mentioned in the cause title, etc., the proper case number. So perhaps in the time of typing, the typographical error has occurred. I'll take you to the FIR.
Yeah, but you see, when the order was dictated, you should have corrected,
Absolutely, Lordship. So when I went home and I checked the video, it seems, Your Lordship, when the order was being dictated, the numbers were not uttered. Your Honor just asked, please copy the number. So I believe while typing that error occurred. Your Honor had mentioned UAP case number 1, but then Your Honor asked the steno to just copy the case number. So in that process, I believe it occurred, Your Lordship. Of course, inadvertent mistake.
Yes, Mr.
Lordship, it's only a minor mistake, Your Lordship.
But Mr. This is set up, learned counsel for the petitioners who have submitted that this court by common judgment and order dated
8th of September 2025.
8/9/2025. At para 6 of this same. Had referred to the connected police case number
Sadar PS 80.
as I underquote Sadar PS case number 80 under bracket 3 of 2024 close, when in fact the petitioners are not at all involved in the said case, but actually are involved in, what is the case number now?
Nompo PS case number 25
Nongpo PS case number 25,
within bracket 03 of 2024.
03 of 2024.
Yes, sir. 2503 of 2024. Nompo PS case.
Accordingly, this appears to be a typographical mistake, and the same may be corrected so as to set the record straight. Next, Mr. Ndishulai, Leonard AJ has no objection to the same on the ground that law permits such correction of clerical, typographical or arithmetical mistakes. In view of the submission made, this petition is allowed. The order dated 8/9/2025 pass in
2025, Lord.
common the common judgment and order dated pass in to ICT BA number 2 is hereby corrected as far as the said contents of para 6 is concerned, to the extent that the words I underquote Sadar PS case number 2 are to be replaced by the words Nongpo PS case
25 3 2000. I'm highly obliged, Lord.
Obliged, Lord.
Item number 3.
Mr. Sheikh, this will take some time, isn't it?
Yes, Lordship. Then main list, yes, Lordship.
We'll take up
Matter in main list and the other matter also, item
we'll
number
take up this item number 10 first. This is a bail application.
10 and then the main list also, Lordship, can be taken after because it will take time.
Fine.
Item number 10.
May it please, Lord. This is a bail application filed by the father of the accused person, Anant Das, my lord, who is in jail since 22/4/2024, my lord. Almost 1 in 8 years old.
Who's appearing for state?
This was one number 3. Conducting counsel will be coming. He was supposed to be in DP, but then he will be coming now, Your Lordship.
You can start.
This bail application is filed by the father of the accused person, my lord, who is in jail, my lord, since 22/4/2024, my lord. Almost 1 year, 8 months, my lord, till date, my lord. Now, Lordship kindly peruse the FIR, my lord, for the allegation against him, my lord, the accused person. And is 14, my lord.
14.
Yes. With reference to the subject, may I read, my lord? Subject cited above, I, so and so, River District would like to inform you that my son is missing since today morning around 8 a.m. dated 25/7/2023. He wore blue and white t-shirt and black pant with red bag, fair skin, and while he was going to school like every day, but today he have not reached the school. Instead, he went to Barniha, River District, as street people informed as the incident happened on the way of lumbering. River District kindly request you to do necessary action on this matter at the earliest. My lord, thereafter the petitioner was arrested. Almost, my lord, he was arrested on 22/4/2024, my lord. After a year, my lord.
After a year.
Almost after a year, my lord. Now, my lord, the trial of the said case is on the verge of, my lord, completion, my lord. Your lordship will find the page 19, my lord. The search sheet, my lord, listed witnesses are there, my lord. Page 19.
Yes.
There are 7 listed witnesses. 4 has already been examined in the case, my lord. Now, your lordship, kindly peruse the bail application filed before the trial court, my lord. Was rejected twice, my lord. Kindly peruse the orders, my lord, page 47. Page 47, my lord. The third paragraph of the page 47, my lord. The relevant being the relevant I read, my lord. Heard learned PP who submitted that the victim in the instant case is a 9-year-old child, and when the TIP was conducted, the victim has identified the accused person. That if the accused person is enlarged on bail, there is every possibility that the accused might threaten the victim and complainant. Further, the learned PP submit that the application for bail of the accused may be considered after, this is important, after the evidence of the complainant and the victim is recorded, my lord. Therefore, since there was no record of the victim, evidence of victim and the informant, the bail was rejected. Subsequently, by order dated 11, my lord, page 49, another bail prayer was also rejected on the same ground, my lord.
No, by this time,
By this time, my lord, the evidence of victim, informant, and 2 other vital witnesses have been
Already.
examined, my lord. Now, my prayer before this honorable court, since the with evidence of the vital witnesses have been already recorded by the trial court, and the case is on the verge of the completion, my lord. For the fair trial, my lord, the petitioner is required to be released on bail so that he can defend his case, my lord. This is my simple prayer, and the order of the learned trial court says, my lord, that is the thing, my lord. That's why bail was not granted.
yes, Mr. Kaul.
Lordship, first objection, Lordship, is who is Ananta Deb, Lordship? Does he have any locus to file this instant application? Lordship, Ananta Deb is the father of the accused. As your Lordship has as we had prosecution has submitted in the earlier bail application, Lordship, whereby the wife had filed on behalf of the husband, Lordship. Objections were filed, but then, your Lordship, the matter was withdrawn on this basis, Lordship. Hence, I'm taking up this, bringing this objections again, Lordship. Who is a applicant herein? Lordship, is the accused herein by any chance handicapped in filing this instant application, Lordship? There would, in my humble submission, Lordship, there would be certain ramifications if bail was granted without the, if it was not filed by the accused himself. Number 2, Lordship, is has there been any factual changes in the last 2 bail applications which were filed before the lower court? There were nothing, Lordship. And Lordship, my apologies, the Karnataka Council is NG Shila. I just got to file this morning. I couldn't get to read it properly. Hence, I can't think. But then, if my Lordship allows me to file my objections, since Lordship, I just got to brief half an hour back.
Hey, you have the petition with you.
Yes, Lordship, I just got a soft copy a while back, and if the matter can be taken up at the second half, Lordship, I'll be able to.
No, second half.
Then, your Lordship.
At the most, we'll. But anyway.
Yeah, Lordship, those are main objections,
Mr.
Lordship.
Saki, I think first you have to address that. That
My
objection.
lord, what happened, my lord? The practice in the Guwahati High Court, my lord. The bail earlier approached this honorable court by filing a bail application on behalf of the accused himself, my lord. The registry told us that this is not acceptable by this honorable court. That's why you have done this, my lord. It is not on our part, my lord.
No, you mean to say that?
Earlier, my lord, bail that is was pending, my lord.
No, earlier
That petition have been submitted before the office of the PP, my lord.
Yes.
Filed by the accused person.
No, filed with the accused himself.
My lord, accused himself, my lord. But the registry when said, my lord, this is defective, my lord.
Really?
Then we filed this petition.
Lordship, how is this?
And for the 10 times we are visiting this honorable court, my lord. And for
Lordship,
filing this case, my lord, 4 times my lord, we have visited.
An affected party, how can you not?
What is the law in this regard?
Lordship, that's what in this regard, Lordship, I can just.
Or any rules, you see, either High Court rules or any other rules which says that it is, it is incumbent, or rather, it is the accused himself who should prefer the application, and not, through any of his next friends or something.
Lordship, next friend, Lordship, as per my limited understanding of law, subject to correction, Lordship, unless the accused himself is unable to approach the court by some circumstance of being handicapped or being injured or some other circumstances which may happen, Lordship, then he can approach the court through a friend or relative or so forth. But then out here, Lordship, in the affidavit of the petitioner, nothing has been stated of what is the difficulty in approaching. Why the father had to approach, why couldn't the accused himself approach the court, Lordship?
No, but I think we have to settle this issue once and for all, because this will have a...
This is the ukalatnama of the accused person while filing the initial petition, my lord. And that we have take back, my lord, from the registry.
Then let the petitioner, let the applicant withdraw the
And
petition.
I have some orders, my lord, passed by your lordship, my lord. The bail petition is filed by the father, my lord.
But then this issue has not been resolved yet, Lordship.
You see, this point has been raised only recently.
My lord.
Otherwise, like you said, practice here is we also do accept petition filed by mother, father, brother, whatever.
My lord.
But of course, that aspect of the matter, whether the accused himself is
barred from
has
apologies.
authorized
My lord.
such person.
So for the registry of this honorable court, my lord, we have filed, my lord, according to the rules of the registry, my lord. I have contacted the registrar, my lord. He said, my lord, this is the procedure, my lord. Bail petition should be filed by the either of the family members or next of kin, my lord. That's why you have filed it.
Is there any rule?
No, they have not supplied any rules, my lord. In fact, one judgment has been supplied to us passed by a lordship, my lord.
Lordship,
In BA number 14 of 2025.
Oh, Mr. Karolang, you have to satisfy this court.
Balwinder Singh, my lord.
Lordship,
Firstly,
then
you satisfy this court that it is incumbent upon the accused himself to file the petition. Number one. If it's in circumstances where he is, like you said, handicapped, not able to to
approach the court,
or sign the papers, whatever, he is just required to sign the papers.
Lordship.
Then his next friend, that is the father, mother, whatever, can come and approach you. So you have to satisfy this on that point. And Mr. Seki also the same thing. Otherwise, if reference can be made to the rules or practice or precedent, then matter can be settled once and for all. Otherwise, we are on this issue, going up and down makes no. But the fact remains that you should have raised this objection initially. See, when the petition was moved, at that point of time, Mr. Sagi has come from Guwahati. He is coming up and down for this case.
I can place, my lord, the one BA order passed by lordship, my lord, in BA number 14 of 25. That is by the wife.
That is okay.
My lord.
Like I said earlier, perhaps such an order has been passed by this court, allowed, since there was no objection at all.
My lord.
But now that objection has been raised, as far as maintainability is concerned, then the court has to look into it and pass an order accordingly, either rejecting or allowing such objection.
My lord.
So that has to be clear now, because as of now you don't have anything, neither in support of your contention or Mr. Karolang in support of his contention.
I filed
the only thing is if you just confirm from registry what is exactly the rules which says. We'll do one thing. Can you just do it?
Maybe his lordship. If matter can come up on Monday, lordship, I'll file my objections to.
We'll take it up at the end of the board. I'll take up the other matter first. That will take some time, maybe.
Then
half an hour or so.
At 2, my lord, then I'll file my objections by 2. Written objections on this regard, lordship. I just take up the same objections which were taken in the earlier bail application, lordship, which were not taken by your lordship.
At 2, my lord.
Okay, at 2.
Obliged.
But if you file the objection, you have to give him a copy.
Lordship,
He
I'll
has to
supply.
respond.
I'll supply.
But you have time to respond within that time.
Well, let's see, my lord.
Hence, Lordship,
Well, my problem is that, my lord, once the time is taken, my lord, the trial will be over, my lord.
Yes, yes.
That is
No,
my
we
problem.
cannot.
hence, Lordship, I can do one thing. If matter can.
As I said, Mr. Sagar, the other day, I
My
said,
lord.
if you cannot come physically also, you
My
can appear online.
My lord.
So that is no problem. Otherwise, what we'll do is we'll fix this case Monday. Today is Friday, isn't it?
Lordship.
This is Friday.
We'll fix it Monday. In the meantime, today you file your objection. He file his response.
My lord.
Matter is taken out on Monday.
Lordship, I can take Mr. Saiker's phone number and email address. I can mail him the thing. I can leave now also.
That can be done.
I can mail him the soft copy and the PDF copy of the objections. I'll file it
Yes, you can.
before this court. And on Monday or by tomorrow itself, he can file me. He can send me the reply or whatever he wish,
My lord.
and we can have the hearing on Monday itself.
We'll have it on Monday.
My lord. No problem. Throw busy, my lord.
True VC. Heard Mr. P.J. Saikal and counsel for the petitioner. However, in course of hearing, Mr. A.H. Kharwalang, additional PP, has raised the preliminary objection on grounds of maintainability of this petition, challenging the locus standi of the petitioner herein. The learned additional PP has, however, further submitted that the state respondent may be allowed to file an affidavit in this regard to bring such objection in written form. Mr. Saikal and counsel for the petitioner has submitted that he may be anything.
My lord, affidavit may be.
You have to file an affidavit. Otherwise, how would you bring it?
My lord, it'll be like a sort of a written objections, the submissions.
Written objection, whatever. And see, since we are raising the issue of maintainability,
What?
I think it can be done. Who is to swear the affidavit?
Lordship, the IO is from Boy.
She was on medical leave, my lord. Maternity leave, my lord. Earlier, my senior has.
Lordship, so might be a bit difficult since.
Okay.
Because on the earlier.
Puli biang tu ke sente tu ke mau tu ke sedang. M has submitted that he may be allowed to file a written submission in this regard.
Yes.
To which the learned counsel for the petitioner has submitted that he may also be allowed to file a response to such written submission.
If at all required, my lord.
If at all required.
My lord.
Accordingly, as prayed for, let this matter for further hearing on Monday.
Throw busy, my lord.
Lordship, Lord.
That is okay. See,
Biblio.
kuno isi dalam tu si have informed itu, makin appear by VC. Should note down. You'll get I think the link and all those things.
Okay.
You can inquire from the registry.
Obliged.
Lordship, Lord.
Daily list item number 1.
I'm for the petitioner, Your Lordship. My lords, on the last occasion,
It's for we have completed the arguments and all. It's in their part.
only I'm left, Your Lordship, respondent number 2 in this case. Okay. So if I may be allowed to, Your Lordship.
How long will it take?
10 minutes, Your Lordship.
10 minutes.
10 minutes.
So if it takes longer time, then we'll have to allow the the other case to be taken up first.
No, just 10 minutes, Your Lordship. Short submission, Your Lordship.
You are respondent number?
I'm respondent number 2, Your Lordship, the owner of the vehicle.
Or you're the owner?
Yes, Your Lordship.
And who is respondent number 1? Who is respondent number 1?
The victim, Your Lordship.
Yes, you.
The claimant.
You're the claimant. And respondent number 3? Who is respondent number 3? Driver. Okay. So the appeal has been filed by the insurance company?
Insurance company, Your Lordship.
Against the award?
Against the award, Your Lordship. Or
Award.
bypassed by the tribunal.
Then it's the claimant who should respond first.
Actually, they've already completed, Your Lordship. Only I am left. Only respondent number 2, the owner is left, Your Lordship.
Yes.
May I be pleased, Your Lordship? Your Lordship, in this case, I am the owner of the vehicle, Your Lordship, whereby I've also stated before the tribunal that this vehicle was given on rent to respondent number 3, Your Lordship.
Yes.
Your Lordship, in this case, Your Lordship, the learned tribunal, Your Lordship, below has noted that even after multiple of times, Your Lordship, calling the appellant insurance company to come and appear before this before the learned tribunal, but from their side, Your Lordship, they never appeared, Your Lordship. In that case, Your Lordship, they have waived their right, Your Lordship, to agitate it at the tribunal, Your Lordship. So here the doctrine of waiver applies, Your Lordship. Your Lordship, I would also like to take Your Lordship to para 6 of their writ petition, Your Lordship, at page 6.
Page 6.
Page 6, para 6, Your Lordship,
Yes.
whereby the appellant, in this case, Your Lordship, have admitted that since they're relying on the CW4, Your Lordship, evidence of CW4, that is the IO, they did not want to appear and agitate before the learned tribunal, Your Lordship. Your Lordship, I would also like to take you to para number 69 of the judgment, Your Lordship. What's the page number? There's no page number. Para 69 of the judgment passed by the tribunal, Your Lordship.
Where is the judgment?
My Lord, actually the received copy that we got also, there's no page numbering, Your Lordship.
Is there any paperwork here?
There's no paperwork, Your Lordship, just which page number? Page number 14 of the judgment, Your Lordship.
No, where is the judgment? This judgment has something attached here.
Page number.
Okay. Sorry. Para
Page 14 of the judgment, Your Lordship.
14.
Yes, Your Lordship.
14.
Page 14 of the judgment.
There's one. What do you cut?
Para 69, Your Lordship.
Yes.
My Lord, last 4 lines, Your Lordship, if I may be allowed to read of this judgment. The owner and the driver was never examined as a witness by the insurance company OP number 3. In order to avoid its liability by the insurance company, it's not sufficient to show that the person driving at the time of the accident was duly licensed. The insurance company must establish the breach on the part of the insured. So, my Lord, in this case, Your Lordship, even after several notices issued by the tribunal to the company to come and appear before them, Your Lordship, they have already waived their right, Your Lordship. And I pray that, and this judgment and order passed by the learned tribunal, Your Lordship, warrant no interference, Your Lordship. And I pray that the money can be, any form of direction can be, for the money can be directed to the insurance company to be paid, Your Lordship. And my Lord, I also want to make a small prayer, Your Lordship, that at the time of paying the insurance, Your Lordship, I paid the insurance for first party, Your Lordship. But the company never explained to me, Your Lordship, about what are the ill effects if I do not comply to the conditions of the insurance company, Your Lordship.
Have you raised that issue point in your written statement?
Yes, we have below the learned tribunal, we have raised, Your Lordship. We've also submitted that this vehicle, or Your Lordship, I have given it on lease to the respondent number 3, Your Lordship, who was the authorized person. The respondent number 3's handyman has driven who is the driver in this case, Your Lordship, has driven the vehicle, Your Lordship, not my driver, Your Lordship. This is what was submitted before the learned tribunal, Your Lordship.
You have to get it. You have to get it translated.
Translated. My apologies, Your Lordship.
And you have to also give a copy of the.
My Lords, at the time of filing my written submission, I'll enclose this document also, Your Lordship.
No, that will not do.
Yes, Your Lordship.
If you have raised contention.
Yes, Your Lordship.
As regard the status of the driver.
Yes, Your Lordship.
Or rather the person who has driven the vehicle at the relevant point of time. Then that becomes a point of argument which has to be countered.
Yes, Your Lordship.
You cannot take them by surprise at this point of time.
No, Your Lordship. This was given at the tribunal, Your Lordship, at the trial stage, Your Lordship.
We are not talking about trials. We are talking
Yes,
about
Your Lordship.
the argument.
Yes, Your Lordship.
This is not part of the record.
From what I've informed my clients, that they've given this.
No, is it part of the record here?
No, Your Lordship. No. But they've submitted this before the learned tribunal, Your Lordship, at that point of time.
Has the tribunal taken cognizance of this?
I'm not aware. I have to ask, Your Lordship.
You have to look at the judgment.
The judgment.
If the tribunal has taken note of this in the judgment, then
yes, Your Lordship,
it can be taken, can be looked into. But if it comes,
Your Lordship, with regards to this document, Your Lordship, it is silent on the judgment, Your Lordship. It is silent on the judgment with regards to this document.
Then you cannot rely.
Yes, Your Lordship.
Rely on this document now. If you wish to, then you have to file, proper application. I think order 41 to Rule 27, if I'm not mistaken.
Your Lordship will file a proper application in regards to this document, Your Lordship.
If you feel that this is material to you,
yes, Your Lordship.
You feel that your case will hinge on this, then you have to give the other side, ample time to counter, and that you have to file it not in this way.
Then it's not required, Your Lordship. It won't be required to file. I just want to bring it to the notice of this court, Your Lordship, that because since from the appellant side they have agitated that it is my driver, Your Lordship, but then this vehicle has been given on lease to the respondent number 3, Your Lordship. I do not have anything to do with the driver in this case, Your Lordship. He is not neither my employee also, Your Lordship.
Okay. So you're not pressing on this?
No, Your Lordship, but I'm pressing that we have paid the insurance company as a first party, Your Lordship, and then at the first party, like it covers up to the not involved, Your Lordship, so the insurance company is liable to pay the compensation to the claimant, Your Lordship.
Okay.
Obliged, Your Lordship.
May I please, Your Lordship? My only prayer is we may be allowed to file a written argument.
You can file. All the parties can file. Or this is there are counsel for the respondent number 2, who has concluded his argument. all the respective parties have advanced their arguments. In this case, it is the further submission of the counsel for the parties for a written statement, a written argument to be filed in this case. Pray aloud that the written argument be filed within the next date fix. This is matter up to 2 weeks.
My lords, if I pray after 3 weeks, because I will not be in station, my lord.
3 weeks.
Oblige, my lord.
Much obliged.
Second call from supplementary list, item number 3.
Yes.
The factual aspect so far in item number 3 is concerned, lordship, I have covered, and item number 4 is connected, lordship. So I'll just briefly, lordship, I'll
3 and 4 you said are almost identical.
yes, but still I'll just fact, lordship, because he is in the secondary section and the the petitioner item number 4 is in higher secondary section. The facts are more or less same, but still I'll just, because since the other side has raised that one by one, I'll just, then after that, for both the item, I will place some citation and I'll argue on law point, lordship. I'll briefly for item number 4, lordship.
Abdul Bashir Sarkar.
Yes, lordship. He is assistant lecturer, lordship,
Yes.
in higher secondary section, lordship. He was appointed in 2004, lordship. (2012), lordship. 2012.
Where was the appointment?
In para 3, lordship, that because that is not disputed, lordship, since I have been terminated. So para 3 I have mentioned. Page 3, lordship.
Yes.
Page 3. Now lordship will now complain that annexure 1, that is at page 14, that similar complaint.
Yes. Yes.
These were similar, lordship, identical. Even that is first given to the principal.
Page 40.
Page 14, 1-4, lordship. So I am not reading out the complaint because I have already.
No, in this complaint,
These are we have given to the principal saying that
this
please,
is your complaint. Oh,
yes,
this is a joint complaint.
joint lordship. These are joint complaint. These complaints are to show the conduct of the principal cum secretary.
Yes.
That how he was doing with the teachers.
Yes.
Now, then annexure 3, page 16, this is also same complaint that first we given to the district school education officer, that is 7th April 2017. And that is one of the charge they have, the principal has put against me, that why I have lost a complaint against the principal to the DSO. This is also another complaint. This is joint complaint, lordship. Now next also 21st, this is also joint complaint. These are the part and parcel of the. Now
So this 16 is it a fresh complaint or reminder?
no, 16 is all. This is just lordship. We can say this is a earlier the reminder.
Sorry.
Reminder. not 16 Lordship, 7 April or 2016 complaint Lordship, that is at page 15 Lordship. This is fresh complaint Lordship. My Lord is talking about page 15.
Page 16. You referring to 16?
16 is yes. This is the first complaint we have given to the DSEO, page 16.
Yes.
Then next complaint is the reminder, 21st April.
Okay.
This is a common complaint we have lost.
DSEO.
DSEO. The signatories are all the teachers, like secondary and higher secondary.
Yes.
Now subsequently, based on a complaint given by one that social activist, then the managing committee was taken over, dissolved in 15, that is also same 15/5/2017. Then magistrate, that board was constituted by the DC to conduct an inquiry. That inquiry was also held on, that is also part and parcel of the earlier. Now everything is same Lordship. I'll just come to the show cause. Now here also page 34 Lordship will find 33, the chart, one of the recommendation. The government has acted one of the recommendation with regard to payment of salary.
Yes.
Directly to be credited from the office of the government to the teachers. That is the chart, page 34 and 35. The petitioner's name will be below Lordship at the serial number 5 in both the pages. And top 34 and 35, yes Lordship.
Yes.
Lordship will, that page number will be after that amendment. Which page this one? 33? 33 and 34 Lordship.
Yes.
This is a chart for 10 teachers, 9 teachers.
Okay.
So below item number 5, serial number 5 is the Abdul Basit Sarkar, assistant lecturer. The period is given for salary.
Yes.
And next page also Lordship same, the period is given. Now Lordship, now in February, that Mr. S.K. Shah, who was the SDSEO till 17 to first part of 18, he retired. Now Mr. B.G. Momin has come. Now moment he assumed the power, then he first what he did, he drew the principal. He restored or reinstate the principal. That is one of the recommendation of the inquiry committee. Moment he assumed, then the order whereby he was demoted was cancelled. Now after cancellation, what the cancellation was done 8 March 2018. That is also same Lordship. Then after the cancellation, what he did, he restored the managing committee. He restored the managing committee. That managing committee restoration was given. Then after that, that order was passed 19 March. Then after that, 16 March 2017, given a show cause notice. This show cause notice is more or less same Lordship. Why I refused to accept the letter in 2014, 15, 16. Why I misbehave, why I this and that. These are more or less same. Then after that, I was suspended Lordship. But with regard to the suspension Lordship, they have taken prior permission or approval from the government. The suspension letter will find at page 41.
Yes.
As per the decision of the school managing committee
Yes.
of Garodubi Higher Secondary School by MC meeting resolution number 3 dated 8/4/2018. My Lord will kindly appreciate managing committee, he restored March immediately. He was issued show cause notice on 26. Then subsequently I was suspended. But in that suspension order, they have mentioned with is duly approved by the district school education officer by memo number so and so dated 10th April. Resolution for my suspension was taken on 8th April, but the approval for my suspension was obtained on 10th April, and I was suspended on 11th April. Then, so far as the suspension is concerned, they have taken the prior approval. After that, on the next day, I was suspended. Then against the suspension, because same time 2 teachers were suspended and 2 teachers were terminated. These 4 teachers, they filed representation before the director, and director has set aside the termination with regard to other 2 teachers. And so far as the suspension is concerned, the director has said that you follow the due process of law. The due process of law prescribed in the Meghalaya Discipline and Appeals Rules 2011, although it is not prescribed in the Meghalaya Education Act, because the procedure is laid down in that. He said that you draw a proceeding as per a specific provision of law, like give charge sheet, list of witness, this and that. So after that, Lordship, now then 47, this is the second show cause notice given, Lordship. Page 47, Lordship. Since suspension also culminated in the termination, Lordship, though I am not pressing on suspension. Why I am stressing on suspension, Lordship? Because with regard to suspension, the managing committee has taken prior approval in the 2018 itself. But with regard to the termination, he was referring the approval order of 2016. And government categorically in this case has admitted that position that was not obtained. I'll just read the second show cause notice, Lordship. This page 47, this is the reiteration of the earlier show cause notice, page 47.
Dated 24.
Dated, Lordship, 24 August 2018.
Yes.
This is with reference to the earlier show cause, Lordship, that is before my suspension. As you did not reply the earlier show cause notice served to you by the undersigned memo mentioned under reference, for which you have been placed under suspension as per the decision of the school managing committee byte number so and so, with due approval of the DSEO byte memo number dated 10th April 2018, pending inquiry into the allegation leveled against you in the purported show cause notice dated 26/3/2018. From the point of law, the inquiry and interim has been conducted, and the undersigned is likely to expedite disciplinary proceeding against you in the revocation of your suspension order, or further to impose punitive action upon you, whatever you deem fit and proper. But in the meantime, it is revealed that the additional allegation and charges has been found against you by the inquiry team headed by District School Education Officer so and so 27/2018. My lord, that is not the inquiry against the petitioner. That was the inquiry so-called inquiry against the principal, just to give clean sheet that he was not involved in the corruption, who was done by the busy moment. So, serve on given ample opportunity to you to show cause before the managing committee of the school prior to disciplinary initiate action against you. Now you are directed to represent cause against the charges and allegation mentioned below within 110 from the date of the issue of the show cause notice. Now, number 1, Lordship, that you have lost complaint dated 7/5/2018 to the Honorable Chief Minister against the impugned, wherein by para 1 and 2 allege that partial salary has been received by you in the month of December 2013, January, February, August 2016 from the undersigned. But it is found in records that you have received full amount of monthly salary for the above mentioned months as per your pay fixed by the MC. That is blatant lie. Why I am saying lie, Lordship? When the inquiry team sent by the Lokaayukta,
Yes.
they asked for the payment register, the attendance registers, but they threaten the officer that I'll not give. So where from he is? He's just making a very vague
Okay.
so and so month as per pay fixed by the MC of the school and due approval of the DSEO Tura. The inquiry team had examined and verified the acquittance roll payment register of the school and found that your signature has been affixed over the revenue stamp in the said register, which clearly proved that you have received the salary for the above mentioned month in full but not in partial. Your such false and fabricated complaint to the head of the state is not only damage the reputation, this is a stereotype, Lordship.
Yes.
The charge that I have filed a complaint before the CM along with the other teachers. Now second, that you have unnecessarily reported the DSEO. By your letter number dated 29 May 2017 that the monthly salary has been drawn by the undersigned for the month of January and February 2018, but the same has been disbursed to you. It would like to state, it would like to say that is it your job to collect your salary from the undersigned in any working day of the school while you are aware regarding the drawing of salary but not the bound duty of the undersigned to make payment of your salary on your reaching your home. What does he mean to say? That it is your duty to come and collect. It is not my duty that I'll make the payment by going your home. And in the response to your report, DSEO has directed the undersigned to release your salary in the above month as early as possible by letter dated so and so with a copy to you also in compliance of the said direction. The undersigned had requested you to collect your salary from the office of the undersigned any working day by letter number so and so. Further, you have requested over mobile to come to the school receiving. This is all blatant lie, Lordship. That has never happened. Now explain, next paragraph, Lordship. Now explain why not you receive your monthly salary for the month of January and February 2018 from the undersigned. Even several requests has been made to you and even intimated by the DSEO Tura dated so and so in your service or your post as an assistant teacher, not disposal or dismissal under managing committee of the school. He is just threatening. Are you not subordinate of the undersigned? Why did you violate the rules and regulation of the school by not receiving your salary for the above mentioned? Is it not you trickery to lodge again false complaint against the undersigned, alleging of non-making of salary to you by collecting false and fact, by concocting fact as alleged by you in earlier several complaints? Why did you not make a reply to the earlier so-called notice dated so and so, which was served on you on so and so? Why action should not be initiated against you for your willful irresponsive? My lord, these are the allegations. Assuming, Lordship, I admit, yes, whether that can be a ground, whether that can constitute a misconduct for my dismissal, my humble and respectable submission is no. Even I am not, if I do not raise any contradiction or the procedural irregularities with regard to the DP Lordship, still this sets of allegation does not at all constitute the misconduct for the removal of the petitioner from service. Now,
So you say that after You see, as far as suspension is concerned, procedure has not been followed.
That is yes, Lordship. Even that is why I have one Supreme Court judgment, Lordship. The Supreme Court judgment only everything was done, but only prior approval was not taken.
Okay.
So Supreme Court after 20 years set aside and not remanded and given the back wages. I have 2-3 judgments, and that is with regard to the Delhi High Court, Delhi Education Act. And Delhi Education Act, my lord, our Meghalaya Education Act is a copy and paste from Delhi Education Act. There is not nothing, everything is ditto. This is, we can say, replica.
Yes.
So I'll rely on that judgment. So that is apart from the procedural irregularity in initiating proceeding against me. This does not constitute a misconduct which warrant my proceeding. Now Lordship will now 4th September. Then after that I'll come to my dismissal order. 4th September, this is a conditional order. Page 50, Lordship.
Yes. What is this order?
This is a conditional order.
Conditional for what?
That I'll just read out, Lordship. That order also, although was passed on 4th September, but the order was dispatched to the petitioner on 26/10/2018. 26/10/2018. Now,
Okay.
I'll just see the condition, Lordship. Hence, the penalty of censure is imposed upon him, Sri Abdul Basit Sarkar, but the meantime, the suspension of service is hereby revoked with the following terms and conditions. That he shall withdraw the false complaint, and I have to give undertaking, so and so. That he shall have to tender written apology to school managing committee. That he shall have to given an undertaking to the principal cum secretary of the school that he shall be sincere in so and so. Failing to fulfill the above terms and condition from serial number 1 to 3 before joining in the post, then his service shall not be treated as reinstated of the MC, may take action against him, further may deem fit and subject to fulfilling the above mentioned condition before joining in his service, Sri so-and-so lecturer history is hereby reinstated in his past with direction to join. This is just to show his bona fide.
Yes.
But you have to give the order to the petitioner, then only they can come and join. No, he dispatched the order and the petitioner had received on 26th of October 2018. This is height and seek. Now Lordship will follow the dismissal order. Next page. Here also the allegation is more or less same, Lordship.
Yes.
Why misbehave with the parent guardian? Why misbehave with the principal? Why I refuse to receive the salary? Why I refuse to receive the letter? Page 51. This is the termination order.
Yes. Dated 21 September.
21 September, because the termination order in both the cases will be the same. The show cause in both the cases will be the same. The wording is more or less same, except he is the assistant teacher and he was the vice principal. Now here also, Lordship, this also the petitioner has received on 14 November 2018. Now the next page, Lordship, will find page 52.
Yes.
Here also they are relying the same resolution as well as the same approval order of 2016. Last para, Lordship.
Yes.
Because factually, although I have retreating the thing, my lord, factually is not that much needed, Lordship, to decide this matter, Lordship. Because law point is enough, Lordship. On the premises above, it is held that good and sufficient reasons My lord, the wording good and sufficient reasons, and that is also one of the words in the Meghalaya Education Act to dismiss or suspend any employees, that good and sufficient reasons has to be assigned. So whatever the allegation assigned in the show cause as well as in the other thing does not constitute that these are the good and sufficient grounds, reasons that the continuance of Sri so-and-so assistant lecturer in service is prima facie detrimental to the interest of education and discipline of the school, and hereby in pursuance to the MC meeting resolution dated 30/10/2016 with due approval of DSEO by letter number so-and-so dated 4/11/2016 and as instructed by the district school education officer by letter number dated 4 November 2016, the service of Sri so-and-so lecturer in Hindi history of Garudubi Higher Secondary is hereby dismissed. My lord, wording is same.
Yes.
Now, so far as why I am stressing on, so far as suspension is concerned, you have taken conscious decision and you have taken prior approval. But so far as the termination of my service, you are relying the resolution and approval of 2016, which as per law does not have any stand. Now, next page is the approval, lordship, of 2016.
Okay.
Page 53, that is the same, lordship, which I have referred in earlier repetition. And the page 54 is the resolution of 2016. Now, lordship, since I have referred the DP proceeding of earlier repetition, lordship,
Yes.
that in this DP proceeding, the inquiry officer are the same, the members of the managing committee. That is why yesterday I said the police managing committee, even judges also managing committee, the inquiry also managing committee, the informant also managing committee. No representative from the government. Apart from the procedural irregularities, lordship, whether I was given charge sheet with list of documents, with list of witnesses, whether my presence was required or not, whether I was given any notice for my appearance in all, that apart, lordship, even by looking at the inquiry report does not test the law how to conduct an inquiry. Now I'll come to the government affidavit, lordship. I am not bothering to refer to the affidavit filed by the managing committee. My lord, that is the same, lordship.
Okay.
Everything is same.
Same with the government.
No, lordship. That earlier,
Or the earlier one.
earlier one. Even the page number will be more or less same. Will be same. But still I'll refer. First I'll come this one, lordship. That affidavit filed by the state respondent 1 to 3, lordship. This is the district school education officer. In page 5, lordship. Page 5. Para will be 17, lordship.
17.
Page 5, lordship.
5 of
5 of the state counterfeit filed by the state respondent, lordship.
state. State is 4 and 5, isn't it?
No, lordship. State respondent 1 to 3. 4 and 5 is the managing committee, lordship.
Oh.
If my lot 1, then I can refer the affidavit filed by the respondent number 4 and 5 managing committee with regard to the proceeding. But this is more or less same, lordship. More or less same. The wording will be the same, lordship.
Okay.
This will be the affidavit of July 2019, Lordship.
Or July. Yes. 29 July.
Page 5, para 17 is very relevant. Now I'll argue on law points, Lordship.
Yes, page 5, para 17.
Para 17, Lordship.
Please.
May I read, Lordship? With regard to the abatement made in para 13, my Lord, prior to that, what is para 13 in my writ petition, Lordship? And in which para they are referring, Lordship? I'll just read out, my Lord. I'll not bother my Lordship to take out para 13. I'll just read from my writ petition. State. Huh? Yes, not mobile, that I am, yes, that is with regard to that, because this is the same they have responded. Para 30, Lordship, what I have stated in my para 30 in my writ petition, Lordship, that the petitioner stated that finally the petition was dismissed from service by it in pin order dated 21/9/2018 by the principal of the school. It is rather surprising that the dismissal order was passed on 21/9/2018 and the decision for such dismissal was taken way back on 30/10/2016 with due approval of the district school education officer on 4/11/2016. The dismissal order was dispatched to the petitioner through post and the petitioner has received the said dismissal order on 14/11/2018. Now I was referring that although the order of dismissal was passed on 21 September 2018, but since prior approval is needed, so they are referring the approval which they have obtained in 2016, which has got no connection with the misconduct which I have committed in 2017 or 18. So in response to that, the government has filed the affidavit. What is that with regard to the abatement made in para 30 of the writ petition, the answering respondent stated that the dismissal of the petitioner was done by the respondent number 4 and 5 and was done without the approval of the competent authority. The letter of approval quoted in the order dated 4/11/2016 appears to be irrelevant and invalid. Therefore, the dismissal of the petitioner is illegal. My Lord,
yes,
same affidavit, although they have not specifically, they have evasive denial, that matter of records. They did not deny, says that it is a matter of records in the counter affidavit of the earlier writ petition. So they have not specifically said that even if they deny also, my Lord, they cannot go beyond the records, Lordship. They cannot say beyond the records. So now, what will happen, Lordship?
yes,
What will happen if the dismissal of an order, if there is no prior approval, if the dismissal of the employee is effected without taking any prior approval, what does the law say? Lordship, now I will come to Meghalaya Education Act, Lordship. My Lord will find that Meghalaya Education Act at page, Lordship, at page 16, Lordship. Page 16, Lordship.
Yes, section.
My lord, will that operative part, the section will be 9, lordship. 9 will be page 27, lordship.
Yes.
The relevant part will be 2, lordship. Very important part, 9 clause 2. The head note says terms and condition of service of employees of recognized private school. 9.2 is relevant for termination and 9.4 is relevant for suspension, lordship.
Yes.
May I read, lordship?
Please.
The state terms and conditions. The state government may make rules regulating these minimum qualification for recruitment and the condition of service of employees in recognized school, provided that neither the salary nor the service conditions of an employee in the employment of an existing recognized school is commence of this one shall be varied so and so. Okay, now, subject to any rule that may be made in this behalf, no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated, except with the prior approval of the competent authority. My lord, I am not required to argue even the DP proceeding, lordship, whether it was correct or not. I am not required to argue whether the allegation that put against me is really constitute a misconduct. I am not required to argue. Since there is a statutory violation, lordship, the entire case, the dismissal order goes. I know, lordship, I have to give written submission, but still I'll just first I'll rely your lordship judgment, lordship, with regard to 9.2. I'll give, sir. I have to give written submission only. Otherwise, I'll give the citation.
Yes.
This is which one? This court, no? This is it, no? Yeah. My lord, will start from para 9.
Yes.
My lord, even otherwise, the school of the petitioner, this is an SSA school, lordship, this is receiving 8, that in this case, lordship. Even otherwise, the school of the petitioner being a recognized private school under the provision of Meghalaya Education Act and is applicable, and subsection 2 of section 9 of the said act is subject to so and so, my lord have quoted the provision. Subject to any rule that may be made in this behalf, no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated except with the prior approval of the competent authority. And this provision has been violated inasmuch as the prior approval of the competent authority, who is the Joint District Mission Coordinator, Dadangiri, has not been obtained by the school authorities before termination of the service of the petitioner. Herein submits the learned counsel. Now this is the Now, what is the observation, lordship?
Yes.
Para 13, lordship. Submission of the state respondent. Mr. R. Gurung, learned additional synergy appearing for the respondent number 1 to 6. This is the government representation.
Yes.
Has submitted that apparently the respondent managing committee, while passing the infant termination order, has not complied with the provision of law as pointed out by the petitioner, particularly the provision of subsection 2 of section 9 of the Meghalaya School Education Act. However, it is also noticed that the petitioner has filed a representation before the respondent number so-and-so, Joint District Mission Coordinator so-and-so, and as such it is further submitted that the attention of the respondent may be directed to the said representation and to dispose of in accordance with law. Now, my lord, heard the submission of the so-and-so, on the face of it, this petition merits consideration as the impending termination order was passed without affording an opportunity to the petitioner to respond to the allegation made therein. The proper procedure has not been followed by the managing committee, and however genuine the grounds for termination may be, for which this court may not enter into discussion of the facts, the principle of natural justice having been violated, the impending termination order has to be set aside and quashed. Para 17, Lordship. In the overall consideration of the matter, the impending termination order dated so-and-so, issued by the petitioner, issued upon the petitioner by the chairman, Rangshai SSA UP School, West Garo Hills, Meghalaya, is hereby set aside and quashed. The petitioner is directed to be reinstated in service. Now, Lordship, I'll rely one judgment of the division bench of the Delhi High Court, Lordship, because that case with regard to the suspension. And here we are referring 9. In Delhi Education Act, Lordship, it is 8, Lordship. The wording is the same, Lordship.
Yes.
So that is, this judgment is relevant, and this judgment is exactly fitting the petitioner case. That judgment, Lordship, the charge sheet as well as the suspension has order set aside by the High Court and directed to reinstate and give the salary. And direction is given to the government to take action against the management.
Yes.
Para 4, Lordship, this is the factual aspect of the judgment. Why I am referring to factual aspect? Just to corroborate my case, Lordship. It is alleged in the petition. Here there are 4 petitioners in this approach before this honorable court. Here we are 7. The grounds more or less is same, Lordship. It is alleged in the petition that the petitioner number 1 and 2 are teaching in the primary section of respondent number 1. Respondent number 1 is the management, Lordship. And the petitioner number 3 and 4 are teaching in the middle section of the school of respondent number 1. Here also some of the petitioners are working in secondary school and some in higher secondary. Now these are the who are the respondents, Lordship. Now para 11. According to the Delhi Education Act 1973 and rules made herein after, the salary fixation so-and-so as per the scale pay fixed by the respondent number 2 and 3, this is the government. According to Rule 107, no school can pay salary to his staff members less than the minimum amount fixed by the so-and-so pay fixation. Now, Lordship will para 12. It is averred in the petition that to circumvent the aforesaid rule, because rule here also they cannot take money, they cannot pay less amount than the sanctioned amount to the teachers. There is an order specifically mentioned, you pay salary to the teachers. It is averred in the petition that to circumvent the aforesaid rule, the management of respondent number has been resorting to devious device to deprive the teacher in their full pay and allowances payable as per law. At the time of giving employment to a teacher, the managing committee gets an account open of the teacher in a bank and takes blank check from the teachers duly signed with 2 signatures at the back of at the time of appointment of the teacher. Salaries are credited in the bank account and are withdrawn by the members of the managing committee utilizing the signed check containing to the check books in their possession. It is alleged that the meager sum of rupees 600 to 800 is paid in cash to the teacher. It is also averred in the petition that the employment being hard to get in this country, the petitioner who come from a lower middle class families and very little option but to suffer under the respondent number 1. A large number of other teachers and employees are also being made to suffer likewise. It is also alleged that having suffered for a long period under respondent number 1, the petitioner have now decided to stand up to the misdeed of the managing committee. Same thing happened, Lordship. All throughout till 2017, we didn't do anything. Just we begging before the managing committee. Now 2017, from March, April onwards, we stand together that no, we have to fight for our justice. It is It is also alleged that having suffered for a long period under the respondent number 1, the petitioner have now decided to stand up to the misdeed of the managing committee. The petitioner wrote letter to the manager of the Oriental Bank of Commerce, so New Delhi, requesting him not to honor any check issued under the signature of the petitioners. It was also mentioned that the withdrawal from the petitioner's account should only be allowed if the petitioners were physically present to receive and withdraw the money from their respective accounts. The petitioners wrote identical letter to the manager of the bank on so. Now para 15. The petitioner started facing harassment at the hands of the managing committee and the principal of respondent number 1. Same lordship here. The principal come to managing committee, that he is the same person. After they have written letter to the banks on so, the petitioner number 2 received a letter issued under the signatories of the principal of respondent number 1 school, wherein she was warned not to make any complaint to the local police. Now para 16. On 27/29/1994, the petitioner number 2 received a memorandum issued under the signature of the manager of the school, calling upon the petitioner to explain as to why she had insulted the manager, the principal, and the member of the managing committee. Same are the allegation in this writ petition, lordship. In the memorandum, she was further called upon to answer why she has instigated the staff against the management. Here the allegation against the principal, that you are the team leader.
Yes.
And further, why she had refused to receive the order. Same lordship. It is submitted that perusal of the letter dated so shows that the allegation raised against therein are very vague. There is no mention as to when the petitioner number 2 has insulted the members of the managing committee, and how the conduct of the petitioner amounted to insulting them. Similarly, it has also not been specified how the petitioner had instigated the management. It is also alleged by the petitioner number 2 that issuance of the memorandum by the manager of respondent number 1 is malified and intended to cause harassment to petitioner number 2, as also to fabricate evidence against the respondent number 2 for contemplated future action.
Yes.
Same thing happened. They have manufactured some document in the year 2016 just to harass the petitioner. Respondent number 2 called upon the petitioner number 3 to submit a photocopy of her passbook by sending a letter dated so. It was alleged that she does not stand to reason as to why the petitioner number 3 was asked to submit a photocopy of the passbook to the respondent number 1, and as to how non-furnishing of the same amounted to violation of official duties. It is also alleged as to cause harassment to petitioner number 4 and fabricated evidence against her. A memorandum was sent through the signature of the principal of the school on 1/8/1994. Petitioner number 4 was charged with issuance of school leaving certificate unsigned, and there were mistakes in the admission and withdrawal register of the school. In reply, the petitioner has mentioned that it was not the job of so-and-so job issue leaving certificate was sole responsibility of the principal, and it was the principal who was responsible for issuing the school leaving certificate without signing the same, if at all they were issued. It was also pointed out that making entries in admission and withdrawal register was not the job of the petitioner number 4. It is alleged that maximum harassment was faced by the petitioner number 1. The petitioner number 1 started receiving letters from the school which contained blank papers. Ultimately, petitioner number 1 had to send a legal notice through a council dated so. It was pointed out in the notice that the respondent number was harassing the petitioner number 1 and creating false evidence against her. Now, it is averred that to harass and humiliate the petitioner number 1, she was placed under suspension. She was also charged with unsatisfactory work, acts of omission and commission, and indulging in union activities and leading to indiscipline in the school. It is alleged that the charges in the memorandum are totally vague and false. No particulars of any act whatsoever which could prima facie substantiate the charges were stated in the memorandum. It is submitted that on so the petitioner number 1 received certificate from respondent number 1 describing her as a able, disciplined, conscious and responsible teacher. Petitioner number 1 was described as producing very good results and was loving teachers to the children. Immediately thereafter, the petitioner number 1 painted black by the respondent number 6 after she had sent a letter to the bank. It was alleged that the memorandum dated so and so on the face of it is illegal and unsustainable in law. It is also alleged that against the illegal action of the respondent number 1, the petitioner had also Teachers Association, Employees Association, of which the petitioners are member, made representation to respondent number 2 and 3, calling upon the said respondent to consider the grievances of the petitioner and direct an inquiry to make into working of the respondent number 1 and take appropriate action. Same thing happened, Lordship. We also lost complaint. Then inquiry, based on our complaint, inquiry was held.
Yes.
Now, Lordship will now para 34, Lordship. After that, I'll come to the operative part of the judgment, Lordship.
Para 34.
34. It is alleged that the petitioner number 1 has not been allowed to report for duty at the school from so-and-so. Same thing happened here also, Lordship. I was not allowed to sign in the attendance register. The attendance register was kept by the principal. After that, what happened? We have to borrow. We have to take one attendance register from the government. Though she is working as a permanent teacher since 1991, the principal of the school has served petitioner number 4 a letter dated 1992 informing that her service, the petition number, was not required in the school. Petitioner number 4 has since been not been allowed to attend duties in the school. It is mentioned in the counter affidavit that services of a permanent employee of a recognized cannot be terminated. The same can be done only after conducting inquiry and after getting approval from the director of school education. Letter dated so and so shows that the management of the school has taken a suo motu action without inquiry. The allegation contained in the letter number so and so are being coming to the school late and has been raising questions are false and contrary to the records of the school. Now, Lordship will the operative part. Page 51, para 51, Lordship. Why I am reading the facts, Lordship? Because these are in fact similar to the facts here in this case.
Yes.
The change of events shows that all the charge sheet, memorandum and letters were issued to the petitioner in the month of June and July 1994. Immediately after the petitioner raised their voice against the illegal action of the respondent in May 1994. Here also same, Lordship. We have raised our voice in 17 and 18. Then immediately he got his reinstatement. Then he started taking all action against me by making frivolous allegation. The teachers who was able, disciplined and conscious and responsible in May 1994, all of a sudden in the next month, she became so indisciplined and had to be put under suspension without resorting to the provisions of the Act. Similarly, the other petitioners have received letters and memorandum in the month of June and July and August 1994. It may be pertinent to mention that before June 1994, not a single memorandum had been issued to any of the 4 teachers. Respondent number 1 had no grievances whatsoever with the petitioner. On contrary, they were extremely happy and pleased with the conduct, behavior and performance. Now, Lordship, according to Rule 8.4, this is, my Lord, if my Lord see the Meghalaya Education Act, Rule 9.4. 9.2 talks about termination.
Yes.
9.4 talks about suspension, Lordship.
Yes.
This is according to Rule Section 8.4 of the Delhi Education Act, which reads as under. I'll just read from here, my Lord can see from the Meghalaya Education Act. Where the managing committee of a recognized private schools intend to suspend any of the employees, such intention shall be communicated to the director and no such suspension shall be made except with the prior approval of the director. Here, competent authority, Lordship, because we have hierarchy of officers, Lordship. So far as LP, that SD SEO, so far as UP and higher secondary, high school, then DSEO, then director and all. So that is why they have used the word competent authority. The rest are same, Lordship. Even the para 9.2 also, Lordship, is same. This is a perimeter provisions of Meghalaya, the Delhi Education Act. Now I'll just skip that para 54 a bit lengthy, Lordship. Now, because here para 54, I'll just read, Lordship, para 54.
Okay.
The language of the section is clear that no suspension shall be made except with the prior approval of the director. Here we are termination, Lordship. I'll come, we have judgment with regard to termination also, Lordship. Admittedly, in this case, there has been no prior approval of the director in accordance with section 8.4. The managing committee may suspend the employee with immediate effect if it is satisfied that the immediate suspension is necessary within the meaning of the code of conduct. In exceptional cases, it may be possible to suspend an employee without taking prior approval of the director, but no such suspension shall remain in force for more than 15 days from the date of suspension unless it has been communicated and approved by the director before the expiry of that period. In this case, till date, the director education has not approved the suspension of the petitioner number 1. This suspension is clearly in violation of section 8.4 of the Delhi Education Act. Consequently, she would be deemed to be in regular service of respondent number 1. Similarly, the memorandum dated so-and-so and so-and-so issued to petitioner number 2 and 4 has been issued out of vindictiveness. Petitioner number 1, 2 and 4 did not receive any memorandum ever before, were flooded with memorandum immediately after they sent a letter to the manager of the bank and made complaint to the local police. Here also same. From the various action of the respondent, it can safely concluded that the respondent number 1, 5 and 6 are running the management of the school in violation of the provisions of Meghalaya Delhi Education Act and Rules 1973. Admittedly, no approval has been received from the respondent number 3. The suspension of petitioner number 1 ceased to be in force as per the mandate of the second proviso of subsection 4 of Section 8 of the Meghalaya Education Act 1973. In view of the matter, the suspension order dated so-and-so is quashed. Similarly, the charge sheet dated so-and-so issued to petitioner number 1 is liable to be quashed because this charge sheet lacks the material particulars that has been issued on extraneous consideration. Consequently, the petitioner number shall be deemed to be in service and would be entitled to salary, allowances and other consequential from 1994 till date when the petitioner has been put under suspension. Now, next 59. We have seen the affidavit filed by the petitioner number 1 so-and-so in which it is mentioned that the respondent have closed the school Shima so-and-so. So-and-so, the school has shifted most of the students to the other school being run by the same family at so-and-so, Uttam Nagar in this case. Since the respondent have closed the school and transferred the student to another school so-and-so, we direct the petitioner number 1 shall be accommodated in that school. The principal of one school is the mother and the other is the daughter. The respondent are directed to pay the salary, other outstanding allowances and due all the petitioners within 1 month from so-and-so. Similarly, the memorandum dated so-and-so issued to the petitioner number 2 and 3 are also liable to be quashed and accordingly ordered. The respondents are restrained from taking any action in pursuance to this said memorandum. My lord, 61 is very important, Lordship.
Yes.
We also direct the Director of Education to conduct an inquiry particularly into the allegation that the managing committee of respondent number 1 has been resorting to dubious devices to deprive the teachers of their full salary and allowances. And if this allegation is found to be correct, in that event, the Director of Education is further directed to take all steps to ensure that the teachers are paid full pay and allowances and rules and the provisions of so-and-so are strictly complied with by the respondent so-and-so. Here, cost also imposed, Lordship. Here same thing, inquiry has been conducted, that parallel inquiry found that he was found in misappropriation of funds. My lord, just now,
You want to stop?
Lordship, I intend to refer two more judgment. It will take time. That is Supreme Court judgment, Lordship. Interpretation of Rule 9.2. One case, Lordship, they have raised the issue of maintainability, that in the Supreme Court whether this writ is maintainable or not. So Supreme Court has said that maintainable, even unaided school also maintainable, and because in one case, because the proceeding was drawn, then after proceeding he was terminated, then no approval was taken. The managing committee has taken a defense that no, once proceeding is taken, has been drawn against the employees, then prior approval is not required. The Supreme Court has turned down that submission, saying that no, even a full-fledged inquiry is taken, the mandate of section 8.2 has to be complied. So in both the cases, Lordship, because interpretation of rule section 9.2 in our Meghalaya Education Act and their Delhi Education Act. So it is a, it might take little time, Lordship. So I'll just, if time permits, Lordship, now one Lordship, I don't want to bother your Lordship.
We'll have to continue next date only.
Yes, Lordship, that's...
Because the respondents are yet to respond.
I'm for from 5 to 9, Lordship.
My lord, after that with regard to statutory violation, Lordship, then I have to cross another hurdles, Lordship. Since somebody has been replaced, in the event if my lord set aside, what will be the consequences? Their appointment. That I'll satisfy your Lordship with Supreme Court judgment, Lordship. The Supreme Court says that when the initial appointment, initial termination, initial action is bad, that subsequent action all collapse.
We'll continue then.
Lordship.
When?
Any day, Lordship. I think Wednesday, next Tuesday, Wednesday, Lordship.
Come 23rd or 24th or 25th. Not next week, Lordship. Not next week.
Then
22nd.
22nd.
No, 23rd.
23rd, Lordship. 23rd. 23rd. I can be fixed on Lordship. 21st, 22 Lordship. If subject to 22.
Lordship, 22 or 22nd.
Because 23rd, sir also having one matter with me in the other court. Then 22.
Heard Mr. S.A. Sheikh, counsel for the petitioner. Hearing is not concluded and will continue on the next date fix. As agreed to by the parties, place this matter for further hearing on
22nd, Lordship.
22nd.
Apply.